You may have heard about the Inheritance Act. This allows a person to bring a claim when they have not been reasonably provided for from a loved one's estate. Claims can be made by spouses, being husbands, wives, civil partners, ex-spouses, children, being biological and adopted, children of the family, which is anyone treated by the deceased as a child, dependents, which is anyone who is financially maintained by the deceased, and cohabitees, being anyone who lived with the deceased in a romantic relationship as partners. Reasonable provision for a spousal claim is anything that is considered reasonable in all of the circumstances. However, for any other category of claimant, it's based upon a person's maintenance need, which is what they may require to help them with their day-to-day living if they are in difficult financial circumstances. The claim is made against the deceased's net estate. This is calculated by adding all of the assets of the estate, so things like property, bank accounts, investments, shareholdings, etc. And then taking away any liabilities of the estate, which is the debts, so things like credit cards, loans, mortgages. Assets that fall outside of the estate can also be included. For example, the deceased share of a property or bank account held jointly with somebody else, as well as certain life policies and pensions. Claims are assessed on a number of different factors, being the financial circumstances of the person bringing the claim, the financial circumstances of any beneficiary, who are the individuals who already benefit from the estate, the size and nature of the estate, such as its value, the obligations and responsibilities that the deceased had towards the person bringing the claim or any beneficiary, any mental or physical disability of the person bringing the claim and any beneficiary, and any other matter the court considers relevant, such as the behaviour of the parties. A person has 6 months to start court proceedings from the date of a grant of representation, being the formal document which confirms the validity of the will. It's often known as getting probate. If this time has already passed, it is possible to bring your claim out of time with authority of the court, but it's not guaranteed. So it's best to seek legal advice as soon as possible. In general, we suggest that you make your claim known at the earliest opportunity. Very few claims require a final court hearing. The majority often are solved by attending mediation, which is where an appointed mediator, being a third individual who's completely neutral between the parties, helps the parties come to some sort of agreement, or alternatively by way of a negotiated settlement, which is simply a to and from between the parties until we can find some sort of agreement between everybody. Those sorts of settlements are as legally binding as any court order. Claims can be funded privately. Sometimes insurance is available. If you see your solicitor, it is possible that they can offer a conditional fee agreement, which is often known as no win, no fee, or a deferred payment option, which is where you simply pay your legal costs at a later date. It's best to seek advice from a specialist as soon as possible. Whether you're considering bringing a claim yourself, or perhaps you're a beneficiary or executor against an estate where a claim might be being made, we can help you. Simply call our client coordinator, who'll be able to put you through to a member of the team.